there are instructions that if you find a witness to be, their testimony to be false in part, in other words, they've lied about one thing, you may disbelieve everything they say. I mean, that's kind of the school I came out of is, are you basically an honest person, or are you trying to make a silk purse out of a sow's ear? I don't know. So if I think that somebody, that segues into the next part, which is the testimony. If I think somebody is telling me, when I was a judge, let me give you an example.
Well, good morning, Your Honor. How are you?
I'm great, Peter. How are you today?
I'm doing okay. Still recovering from a little bit of a cold/cough, but I'm so grateful to get your time today to sit with you, chat with you, ask you some questions, introduce you to our clients and maybe some potential clients and just whoever might be watching this. But it's always my honor to sit with you. So
I appreciate that, Peter. Yeah.
So I want to introduce you to folks. And I think one of the things I think about when I think about your rich history of being an attorney and a judge, and I was hoping you could share your history with our audience and maybe back to the beginning, like law school to being a lawyer to being a judge.
Okay, well, I can start with when I was born if you want, but I don't remember that very much.
Perfect. Well, maybe we'll start with like wherever you think is relevant to.
All right. So I came out of high school, and it was during Vietnam, and I was concerned about getting drafted. So I joined the Navy. I served 2 tours in Vietnam on coastal patrol. Had some exciting adventures, managed to survive them, came back, got married, went to college at the University of Oregon, graduated in 1975, and then I started law school at Northwestern Lewis and Clark in Portland, graduated from there in 1978, so I don't know, what is that, 22 plus 23, 45 years.
Yeah, about 45 years ago. I was born in 75, and so yeah, about 45 years ago. So yeah,
I was such a kid, Peter.
Well,
anyway, so after law school, I started a law firm with 2 other guys, and we practiced for about a year and a half. And then I had an opportunity to join the Navy JAG Corps, which I did. I served 3.5 years in the Navy JAG Corps as both a criminal defense lawyer and as a prosecutor. And when I got through with that, I worked for the United States Attorney in Seattle as a special assistant U.S. attorney. And I did that for about a year and a half. And then I went back to Portland and started doing military law all over the world as a civilian. Had some really interesting cases. Kind of got this little niche of homicide defense, which I became reasonably successful at. And then in 1997, I was offered a position as a United States administrative law judge in Portland. And I accepted that position, and I was a judge doing Social Security and Medicare cases for about almost 20 years, and then retired in 2016 and went back into private practice. And I've handled the cases for several thousand people as their attorney in Social Security hearings. I think I have a fairly high success rate because I know the judges and they know me and I know what they're looking for. And if I don't have it in the case, I'll be upfront with them. I'll just say, I know we'd like to see some evidence on this. I'm sorry to tell you I don't have it, but then I'll make an alternative argument. And people say, well, geez, you're so old. Why don't you just retire? But
they don't know you well.
Yeah, I enjoy it. I enjoy helping people. I enjoy doing something well, and I enjoy being successful at it. So, I'm not going to retire. I'll probably never stop doing this. I might drop dead during a hearing, but, hopefully that won't be for a few years.
Wow. Hopefully it won't be for a few dozen years.
Yeah.
So you're being pretty modest because I know your history, and I know, we don't have, I don't want to deep dive into it too much, but I know that some of your cases, in fact, have become very famous in the criminal defense world, and to a point where, and we don't need to name drop the TV show or the movie, but, I know a couple of your murder defense cases or homicide defense cases were so famous that they created a very famous movie about. And so let me ask you about being a JAG attorney. You traveled all over the world representing people, and I think of different movies when I think of JAG lawyers, and but tell folks that's jury trial work. You're standing up in front of folks, people who might not be as familiar with seeing those type of JAG type of trials versus
Sure.
your average trial down at your local county courthouse.
Yeah. Well, a typical case for me during those years before I became a judge, let's say I would get a call about somebody charged with kidnapping and attempted murder in Okinawa, and it might have been a Marine. So I would fly to Okinawa and do all the pretrial preparation, probably make 2 or 3 trips over there. And then a court-martial, which is a trial in the military, is very similar to a trial in the civilian world where you've got a jury. The jury is composed of military officers, some of whom may or may not know the defendant. The rules, the thing I always appreciated about doing military work is the rules are very well defined, and they follow the federal rules of evidence. So it's a technical way to practice law, but once you know it, you know it. And
right.
So I would do a case in Okinawa, and then 2 weeks later I'd be in Frankfurt, Germany, doing another one. Or, I like you said, I've done cases all over the world, and it was a pretty exciting career for me, and it was reasonably lucrative, but it was very difficult to have enough time with my children. And I do have 2 children, and now I've got 7 grandchildren, so I'm pretty pleased about that. But so it was quite an experience.
Yeah, I bet. Extremely cute grandkids, by the way.
Yeah. Thank you.
And I'm unbiased. I'm like, man, those are cute grandbabies. So then you had all this trial work and trial experience, and then to become a Social Security Disability Administrative Law judge in Portland.
Yeah.
At the time, what were the requirements to even become a Social Security judge? Like, did you have to be a lawyer, or most, a lot of folks, they walk into this room and they probably don't know the background of the judge that's in there. They're just, when the claimants came in front of you, you're like, hey, I have all this rich experience in trials, and let's just go. Let's do the hearing.
Yeah.
So maybe like a little bit behind the scenes, you can explain to, whoever is watching, who is generally the basic requirements or the general requirements for the judge just to even sit in that chair and walk us through that a little bit.
Well, it's administrative law is executive branch. So there's 3 branches to the government: executive, judicial, and legislative. And so the district court judges that are appointed by senators and congressmen that's more of a, I don't want to say a beauty contest, but it depends a lot on, your local contacts. And of course, having not done that much locally, but rather having spread out my practice all over the world, that wasn't something that I would necessarily have fell into that niche.
Right.
the executive branch judges, you've got number one requirement is you've got to have 7 years experience as a lawyer. They're used to require a certain amount of trial experience, but they no longer require that. And so you will see a difference in judges between those who've had trial experience, who've had experience sitting in or standing in front of a judge and presenting a case. That's invaluable experience for you as a judge, but it's also invaluable as a representative to have done that for many years. And so the other thing you have to do is take a competitive examination that takes about a day. I think I finished it in 45 minutes because I had enough experience, You've got to have at least 30 references of other lawyers. You've got to have at least 20 references of judges you appeared in front of. And these people all get contacted. And eventually you end up with a score. Office of Personnel Management in Washington, D.C. will give you a score. And so they have what's called a list of eligibles. And those are individuals who have applied to be part of the program, the cadre of administrative law judges. And every year they'll say, okay, we need 20 more judges because we had 20 retirements last year. So they'll go down the list, and according to the score, they will choose the next 20 in line with the highest scores. I know people that have been on that list for years and never been selected because their score wasn't high enough. I was very lucky because of the breadth of my experience. I had a fairly good score, but it's very competitive. I do think there's a big difference in the judges who've done trial work and the judges who've been appointed because they came up through the ranks at Social Security. Very big difference.
That they were a lawyer that used to work for Social Security Disability.
Correct.
Had like trial experience or jury trial experience or outside of Social Security. They just kind of came up through Social Security, and their first court experience is a Social Security hearing, and now they're a judge. And versus like you, who's done world famous trials, and not that you have to do world famous trials, but like you and I,
trial attorney, yeah.
I at one point did a ton of criminal defense work as well.
Yes, you did. Well, let me give you an example. I had a hearing yesterday with a judge who was appointed this last year, and he used to work in the office in Portland writing decisions for me and some of the other judges. So that's a way you can become a judge through the system, is to come up through the ranks. And he's actually turned out to be a pretty good judge, despite the fact that he has no trial experience. But I think part of that is humility. I think that's a very important feature or character trait of good judges is humility. They don't push people around, and they are respectful and courteous to the people that appear in front of them.
So you got a little lucky because you were placed in Portland, Oregon, and such a rich history in Oregon. I mean, you went to Lewis and Clark and University of Oregon, but is that the same for every judge, that they get their first choice or get the city that they want to live in? Or
yeah, no, that's not. I don't want to brag, but I was number one on the list when I was appointed. And so I think they really wanted me. And I told them, if I don't get Portland, I'm not going to be a judge. My children were still in school. It was important to me to be near them. And there are normally, I would say most of the judges, maybe half, they don't get their first choice, but they go, let's say they'll go to Billings, Montana and work there for 2 years. And it's usually a 2-year tour somewhere that the agency needs a judge, but they don't have somebody that lives locally who's qualified. So they'll take somebody out of Portland and send him to Billings. He'll do 2 years there, and then he can come back to Portland if there's an opening, or he can go to Seattle or wherever it is that he wants to be.
Right. And that's, I guess that the reason I ask is because, as you know, you'll see judges go from Portland to Eugene or to Seattle to San Diego.
Yeah.
I don't hear very many judges getting an opportunity to go to Hawaii, but maybe,
Well, there's two of them there, and they're two, and they're both older. So, cross your fingers, Peter.
Well, I'm really happy here, but
Yeah.
maybe Hawaii. I'm sure my wife would say, "Hey, maybe it's time to become a judge." But but it sounds like I'd have to get quite a few references. I was like, man, 30 and 20, that's a lot.
It was huge. Yeah.
So after you get appointed, do you just walk into the hearing? I mean, well, let me ask you this. Before you became a Social Security judge, did you ever do a Social Security case representing anyone in Social Security court?
No, never. I didn't even know they existed,
Social
which
Security,
is kind of bizarre. Yeah.
yeah.
Very strange. But somebody recommended it to me when I was in Washington, D.C. I was also on the list for becoming a United States Court of Appeals judge for the armed forces because I had done so much military work. But I was talking to somebody back there, and he recommended that I apply for this program, which I did. And then once you get appointed, they send you to school. You go to Judges School, I guess, for lack of a better word, and that lasts. I want to say it's about 3 or 4 months, and it's back in Washington D.C. And you learn all the ins and outs of Social Security law, which, yeah.
Let me ask you that. Let me ask you about Judges School. So with Judges School, you're in Washington, D.C., 3 to 4 months, and I'm assuming it's full-time, 5 days a week, 40 hours a week type of deal?
Yeah.
And are you watching other hearings? Are you just, is it like being in a law school classroom? Is it?
It's more didactic, like law school, where you're in a lecture environment, you have written materials, you're responsible for knowing those written materials, and the teachers are all judges. They're all experienced administrative law judges, and they have been chosen because they're good judges. So, yeah.
And then do you actually do a hearing or I guess oversee a hearing while you're in school, or do you get placed first before you do your first?
You get placed first. Yeah. I mean, a lot of times you might get appointed in June, but the next class doesn't start until August. So you will go to your office, like in Portland. You would go to your office and you would observe hearings, just observe until your class starts in Washington.
Right. And then, so you could go observe. You got the job. They're paying you to observe. You go to the school,
Mm-hmm.
come back, and then what is it? You're just instantly hit the ground running, or is it more observation? Is there observation requirements?
I'm not quite sure how it is now, Peter, but for me, there was a mentor, and I was assigned a senior judge as a mentor. As it turned out, he wasn't such a good mentor. he ended up, let's just say he was a little aggressive, and he's not a judge anymore. He was only a judge for a few years after that. And that can make a big difference. My mentor he didn't have an ounce of humility to him, so he was more like, what do you mean you can't walk? Throw those crutches away. You can walk, sort of a thing. And that wasn't particularly helpful for me, but anyway, it worked out.
So you're assigned a mentor. How long do you work with the mentor? Back, and I know we're not talking about, current. You've been retired now for several years, but back in the day, you get assigned a mentor.
Right.
You have to work with that mentor before they allow you just to hit the ground running.
You know, I mean, I was doing hearings the first week. Yeah. And you kind of learn by the seat of your pants, is part of the process. And you sit in on as many hearings as you can just to see how other judges handle issues. There are a lot of issues that you wouldn't normally think of, but one of them would be problematic attorneys. And when I was a judge, there were a few attorneys who were very problematic. And I mean, there was one attorney, as you may recall, who he was so problematic that they had to have 2 security guards in the hearing to prevent him from throwing furniture, books. It didn't matter. He I don't know what his situation was. I think he had a screw loose or something, whatever they say these days.
Well, I think he ended up getting disbarred from Social Security law.
He did. Yeah.
Unheard of.
I know. That's really hard to do.
Yeah. I mean, so, to be fair, and I don't want to deep dive into it too much, but yeah. So you have to deal with problematic attorneys sometimes, and hopefully great attorneys as well.
Yes. Yes, for sure.
I guess, let me ask you this. So as a judge, kind of as a Social Security disability law judge for, 20 years, on average, what is sort of the requirement that Social Security has for you, or to how many hearings you either have to do in a day, or do they count it like that, or in a month, or in a year? Like, what is sort of the expectation from the administration on you guys?
Yeah. So I think the expectation is maybe 40 to 50 hearings a month. Okay. So when I started out, probably the first 10 years I was a judge, it was all paper. Now all the records are electronic. And so you can go on the computer, and if you have the code, you can access the files of various clients and so forth. But in the old days, it was paper. And I would walk into the office on Monday morning, and there would be a stack of files on my desk for my hearings that week. And that stack would be at least 2 feet high. And so you have to read all this stuff. I mean, if you don't have to, there were judges and are judges who don't read the files, but I don't know how you could be a good judge and not read everything in the file. The best judges really know inside and out the medical records of the people that appear in front of them. But that would be typical. I would do, let's say, on a travel docket, let's say I would go to the Dalles and do 20 hearings in a week. So that's 5 a day. Is that 5 a day? No, 4 a day.
About 4 a day. Yeah, it's okay. 4 a day.
That's why I'm a lawyer instead of a mathematician.
Right. We don't run a CPA's office. That's the number one piece of advice I give clients when they call in and asking about financial advice.
Yeah.
So it's about 4 a day. So how, and just to give some perspective, because I would say in my experience of doing, at this point, thousands of hearings and, the average file, I'm not talking about, you and I have both seen files that are 3,000, 4,000, 5,000 pages long, 5,000 to 6,000 pages long. Yeah. That is not average. That is far above average.
Right.
I would say, if I was to guess, the average file is about 500 pages long, give or take 100 pages.
Yeah, I think you're right. Yeah.
So you have to read and prep for 40 hearings a month, a 500-page file per hearing, and you have to read the file.
Right.
You have to conduct these hearings. What is the average time frame that it would take for you, or for, and I'm not saying, the longest or the shortest, but the average time frame for you to conduct a hearing?
The hearing itself would normally run between 45 minutes to an hour and 15, maybe.
Right.
Maybe just average an hour, because the cases are pretty well organized. The statutes that the judge has to apply to the facts are sequential. There's what they call the sequential evaluation process. And so each one of those steps, you might spend, 15 minutes asking questions about, like the past work that the hypothetical, or not the hypothetical, but the claimant, the past work they've done, what are their medical problems? What's the worst one? What kind of evidence is there to prove that? So I'd say about an hour average.
Okay. So then you do the hearing and you ask questions. Now, let me, this kind of came to my mind a little bit because you and I have experience doing criminal work. In criminal cases, when you watch someone prosecute a case on the prosecution side, because they have the burden of proof.
Right.
They have to lay out the whole story to the jury.
Right.
All of the facts from start to finish throughout whatever time frame in the day of what they're trying to prove.
Yeah.
And so sometimes, like and I've never done a homicide defense, or I've done attempted, but not homicide. Some of those jury trials can last weeks.
Oh, yeah.
At a time.
Yeah.
Or even a small misdemeanor trial could last, in our state of DUI, driving under the influence of intoxicants is a misdemeanor. So that could last a full day, maybe even a day and a half if you do a jury trial.
Yeah.
And clients will sometimes ask me, why am I only getting 45 minutes to an hour to present my case?
Yeah.
And I will tell them, and I'd love to hear your perspective, the difference, because I think they think of it as a criminal case. Like, I need to start from the beginning and tell my whole story to the decision maker. What's your thoughts, or how would you respond to a client who you now represent who asks you that?
Peter, that's a really good question, and it points out the big difference between the administrative hearings that occur for Social Security and contested trials. So we have, in Social Security, we have what are called hearings. They aren't trials because there aren't two lawyers duking it out, trying to prove one thing or another to a jury or to a judge. That's one of the things that takes a lot longer in a civil case as opposed to a hearing. A hearing is more, so Social Security law it's inquisitorial, and that means you're asking questions trying to draw conclusions rather than arguing back and forth. This is what I saw. No, this is what I saw. It's usually in Social Security law, the medical records are pretty clear, and the judge has read those. And you go into a hearing and the judge has already read those. You don't have to drill down for an hour and a half trying to determine whether or not this person has ever had a EMG study on their wrists for carpal tunnel, because you've already seen that. So some judges are very lenient about letting counsel present things that they know are already in the record. Some judges, as you know, one of whom is no longer in Portland, they'll just be very curt and say, I've already read the record, counsel. I don't need to hear that. And, as a lawyer, take the hint. You don't want to hear a judge. There's no profit to that.
Right. That's exactly what I tell Social Security clients coming in. I say, hey, look, we're not walking in as a blank slate.
Right.
If you're getting a jury, it's a blank slate. All that evidence has to be slowly presented to a jury from start to finish.
Right.
But in a Social Security hearing, the hearing has already started before you even walked in the door.
Right.
Because we, hopefully, and I think our firm is better than most, but hopefully we have all your medical files in, and hopefully the judge has read it, and we know a lot of the judges. So we'll say, look, we know this judge has read the file. So we know we're not walking in as a blank slate. It's why your hearing is 45 minutes, because we don't need to talk about 4 years.
Right.
History.
Right. And let me just interject here, Peter.
Yeah.
The Evans Disability Law Firm has a reputation among the judges for always having the evidence. Instead of saying, like some of the firms around town, the judge will say, well, where's the evidence on such and such? Oh, Judge, we haven't requested that, or we asked for it, and I can't answer that. No, with the Evans reps, the answers are there and the evidence is there, and that's why you guys have such a high success rate.
Well, thank you. I appreciate you saying that. It's very, very kind. It's something we're constantly striving and working for, is to have not only a good reputation amongst our community and our clients, but definitely having a good reputation amongst the judges. And I think it starts with good lawyering, good file prep, and we do our best. We're not 100%. We never will be. In life, what I've realized is that, when we have to rely on a third party to help us out, and I just did a podcast with John. I mean, some of these folks, these medical records folks, they lose our requests, and we will follow up for 2-3 months and still not get it. Yeah. And they're like, so you have to rely on, these offices, but we do follow up. We do try. We do. It is my expectation on our staff that we bring hope, encouragement, and knowledge. And knowledge is knowing that we have to follow up on certain medical records and knowing what the average time frame is for medical records to come in.
Right.
And really
exactly
closely.
Yeah.
So I appreciate that answer. That's a beautiful answer. It coincides with what I've always believed about kind of judges, and been told to, because I've, over the years, the last 20 some odd years, I've developed pretty good relationships with the judges. Obviously, you and I became friends because,
Well, you were my clerk.
That's right.
When you were in law school. Yeah. That was a long time ago.
Yeah, long time ago. And, but now I want to ask you, some inside baseball that, I've always wondered. Maybe not wondered. I don't know how to phrase this question. So at the end of most hearings, the judge will conclude the hearing and go through it. And they will say typically, okay, thank you for your testimony. I really appreciate you being here today. I'll take it under advisement. I'm not going to make my decision today. I will make a written decision and issue it in the mail sometime in the next 30 to 90 days. If it's longer than 90 days, have your lawyer give me a call.
Yeah.
Are they really making a decision 30 to 90 days from the date of the hearing, or are they making a decision, Johnny, on the spot?
Well, different judges are different.
Sure.
When I was a judge, it would be very rare for me to make a decision in advance, unless it was a favorable decision.
Sure.
If I was
convinced of the hearing, you're saying.
Yeah. If I was convinced, based on the medical evidence, that the claimant met the requirements for the program and that they were disabled, I would tell them right away, counsel, we don't need to waste everybody's time. I'm going to find in favor based on the medical evidence. And that's probably unusual for that to happen. It doesn't happen very often, because otherwise, they would have probably been found disabled at an earlier stage of the proceeding. But the other thing is, I think most judges have kind of an idea as to what way they're leaning when they sit down to hear a case. And so the questioning, as you know, as we've kind of discussed, there are basically 5 questions that you need to answer in order to be found disabled. And that's the judge is looking for the answers to those 5 questions. But usually you're already going to have the answers from the file on maybe 3 of those 5 questions, maybe even 4, in which case, as you know from being my clerk for years, there's maybe one issue that you really need to determine. Was the person actually working during the time that they say that they weren't? And, the agency keeps track of FICA taxes and all that, and it's all in the medical records. And sometimes there's ambiguity in the records. And so that'll be something to clarify. My point as a judge always was, you don't have to take 3 hours to do a hearing if you've only got questions about 2 out of these 5 areas of inquiry. And so, but most judges now, and I think it's because of mistakes that have been made in the past, most judges now will go through all 5 steps, and maybe that makes the claimant feel like they're really getting a full hearing. I don't know that that people felt that they were shortchanged in my hearings if we only went 20 minutes and I only needed to find the answers to 2 questions out of 5. Does that make sense?
Yes, it does. I guess, and just for the audience sake, when you say 5 questions, we're not actually saying 5 testimonial questions.
Right.
Referred to as the sequential evaluation, which breaks down
the issues.
Right.
Correct. Yeah.
So there's 5 issues, because you could get asked 50 questions about one issue. Like, hey, did you work under the table? Where did you work? How much money did you make? And that's addressing question, 1, SGA, and we're looking at that. So but I guess what I'm saying is, what judges will tell clients is that I haven't made up my mind yet.
Yeah.
After the hearing, after the medical records files.
Right.
I believe with 40 hearings to 50 hearings a month, no way you can come back 3 months later to make the decision. I believe, and I don't know this, and this is, so if there's a judge watching this, please forgive me.
Yeah.
This is just a belief of mine. If I had to do 50 hearings a month and I'm trying to go back 3 months ago,
mm-hmm. It's very difficult.
I know. How can I make a decision? I can bear,
Well,
how am I going to remember that? I think they're making a decision that day at the end of the hearing.
I think most judges do. I think you're right. I think most judges do. The way I always did it was I had, so when you make a decision, you have to do instructions, because there's a staff of attorneys that work for the judges who all they do is write decisions. And so, but they can only do that based on the instructions that the judge gives them. So during a hearing, I would be filling out my instructions. And usually by the end of the hearing, I will have made a decision.
Right.
If it's favorable, I would always tell the client, you know what, I'm going to find you disabled, because I don't think it's fair to make them wait another 2 months to find out that they won their case. On the other hand, if I'm undecided or if it's going to be unfavorable, I probably just won't say anything. The other thing is that there may be additional evidence that I want produced that is out there. Let's just say somebody has physical problems. They've got carpal tunnel in their wrists. They've got headaches, but it turns out that they're also depressed. And because they're depressed, they have no energy and, they can't sleep and whatever. I might send them out to see a psychologist, and some judges will do this to investigate. Okay, is there something else there that there isn't any evidence on that might push me over the edge to find them disabled? And so that's not unusual to ask for the judge to order an evaluation on something that isn't addressed, but that might exist.
Right. So you would send them out for what we refer to as a consultative exam or a CE.
Right. Yes.
A psych or physical or nerve conduction.
Right.
Or things like that.
Yeah.
So that does answer my question in a way that and working for judges, I sort of knew inside.
Yeah.
They're not waiting. They're making a decision, Johnny, on the spot. You have
For the most part. Yeah. But you really want to tell somebody at a hearing, I'm sorry, Mr. Smith, you need to go get a job.
Yeah, of course not. Of course
you don't want to have to do that. I mean, maybe that's how you feel, but that's not giving them a courteous hearing. That's
right.
And so you don't tell them anything. I would never tell somebody, well, I can't say I would never. There were occasions, but usually you wouldn't tell somebody if you were leaning toward a denial.
Right. Right. I mean, and then, you never know what that interaction would be. You brought up something that I wanted to ask you about and kind of get out there. You have a team of lawyers that are assigned to you or kind of assigned to a group of judges that literally will write out decisions.
Right.
How often, or did you ever, or judges, maybe, and maybe you can speak to yourself, or kind of the era of when you were a judge, how often do judges write their own decisions?
That's a very good question, Peter. When I started, I insisted on writing my own decisions, but as I did more and more cases, I couldn't keep up with it. So it doesn't happen. It's very rare. A judge if he wants to make a point in a decision, he may interject a paragraph or reword something, but the judges don't have time really to write the decisions themselves.
Right. But your name would go on the decision,
right.
Someone who's reviewed it, made some edits, and got the decision out the door. So
then the normal,
right?
Yeah. The normal course would be you would get a draft from one of the staff attorneys who would have written a draft decision based on your instructions. You would take a look at that draft, and then you would decide if you wanted to change things. You would go ahead and just change them on the draft, and then you send it back, and it gets rewritten as a final, and then you sign it, and it's out the door.
Right. Yeah. One of the things that clients will say to me sometimes if they get a denial, I never said that, and that's just absolutely wrong. And were they in the same hearing as me? And and I'll say, actually, they weren't. The person who wrote this was not in the same hearing. Now, I do know a few decision writers, obviously, throughout my career, and someone who used to work for me ended up going to be a decision writer for Social Security. So we, from time to time, will, kind of check in. It's been a while, but anyway, and it is interesting because, they will have to kind of listen to the audio recording of the hearing. Yeah. They can pick up something, but they weren't actually involved in the hearing. And so generally the writers, but I didn't know what percentage, if any, of the judges who wrote their own decisions. A typical, and I know we're deep diving into kind of being a Social Security judge, and I appreciate that a lot. And I kind of wanted some inside baseball stuff. A typical work week for a judge is, let's just call it a 40-hour work week if it is, right? We probably know it's not. But what percentage of the time is performing hearings? What percentage is going to prepping a file? And then what is done with the rest of the time, if any, left over? Other than reviewing decisions and signing your name?
There's always more work than there is time as a judge. When I look at what the judges are doing, I'm kind of amazed that I ever was able to keep up that pace. I mean, that's not easy to read that much medical record and remember, take notes. I would have 5-10 pages of notes after reading medical records. That takes a lot of time, and I'm pretty much a speed reader, but there's never enough time to do, and that's why there's a backlog of cases. That's why it takes a year to a year and a half to get your hearing, because there are so many cases in the pipeline because it's a very cumbersome process, but it's required for due process under the law. It's required, I think a judge owes it to the public to take that kind of deliberation and time to make a good record in a hearing and a decision.
You've been on both ends of now representing clients in front of the Social Security Administration, in front of judges. I sort of joke, not even joke, but I chuckle a little bit because I know you're now going in front of judges that you have literally trained. Mm-hmm. And so I chuckle a little bit about that. I think that's fantastic and great because now you know what that judge is thinking, even before you walk in the room.
Yeah.
I have a question, and without saying names or without kind of throwing too many people under the bus, what's your theory, if you have one, or if you've thought about this, about why you'll run into some judges that maybe have an award rate of they'll pay or fine fully favorable disabled folks maybe 10 out of 100, like a 10% award rate.
Yeah.
And you'll run into some judges that have a 70% award rate. The national average is, I think, right around 50, between 45 and 50%, depending on the year.
Yeah.
Usually a little under 50. Do you have any theories on why a judge? I mean, you guys all went to the same judges school. You all have the law doesn't change.
Yeah.
Do you have a theory on that?
Well, yeah, my theory is they should make these judges have a psychological evaluation before they get appointed. That 10% judge, I think it is that judge's disposition to be suspicious of everybody. The 70% judge, we're talking Santa Claus. You have somebody who's got a big heart and is very compassionate and tends to believe people. And then you've got this continuum. You got your 10% here and your 70% here. I've never heard of more than maybe 80%.
Yeah.
But at those two extremes, those are called outliers, and that means that they are outside that bell curve. And most of the judges are in that bell curve that's maybe between 40 and 55 or 60% success. Yeah. So there's nothing you can do about it, though. If you've got an outlier judge and they're 10%, there is nothing a lawyer can do about it. You can tell a client, look, I'm going to make the best record I can. I'm going to make sure that all of the evidence is in, and that way, if we lose the case, we'll appeal.
Right.
Yeah.
What? And I know I'm taking a ton of your time this morning, so I appreciate it.
Oh, I'm enjoying it. Yeah.
I have a few more questions that I'm really curious about. That I theorize, and I know every judge is different, and every judge, like you said, there's outliers. Some have that disposition to not believe people, or look for the worst in humanity or people that are in front of them. And you have a judge who looks for the best and believes everything people.
Yeah, yeah.
But generally speaking, what percentage as a judge, what percentage of the case? And when I'm talking about the case, I'm talking about medical records, I'm talking about Social Security forms, I'm talking about testimony, witness letters, witness statements, witnesses coming into the hearing. What percentage of weight would you give in a case to each of those things I just mentioned? And if you want me to repeat it, I'm happy to do that as well.
I'd say most of the judges would give the greatest weight to the medical records. If you have a client who, for the very first time, says to the judge, Oh, I have migraine headaches. Oh, when do you have migraine headaches? Well, I have one right now. I had one yesterday. How long have you been having migraines? Oh, for years. Well, how come it's not in your medical records? Have you ever complained to the doctor? No, I wouldn't complain. I just tough it out. Well, frankly, if there's no reference to something in the medical record, it's kind of a hard sell with a judge. And I kind of hearken back to my work as a trial lawyer. There are instructions that if you find a witness to be their testimony to be false in part, in other words, they've lied about one thing, you may disbelieve everything they say. I mean, that's kind of the school I came out of is, are you basically an honest person, or are you trying to make a silk purse out of a sow's ear? I don't know. So if I think that that segues into the next part, which is the testimony. If I think somebody is telling me, when I was a judge, let me give you an example. When I was a judge, I had a guy come in and say that he was a POW in Vietnam. Well, I had his military records in front of me. He was never a POW. He was never in Vietnam. He went AWOL from the army in Germany, but he lied about it. So somebody that's going to make that kind of a lie, it's pretty hard to believe much of anything that they have to say.
Right.
I think most people are basically pretty honest. There are some who are not, but I think most people are basically pretty honest. And so I will listen to testimony, and if I think the person is being pretty honest, I'll credit that. Okay, I understand, and I'm going to assume that you're telling the truth. Unless, like I said, unless somebody tells a real whopper, so.
Let me ask you, let's assume they're telling the truth, and they say, let's assume that you believe they're telling the truth, and that so far everything they have told you in a hearing as a judge has been consistent, and there's still no medical records to support it. From a legal standpoint, can you credit it? Or do you feel like you can credit it in the same way? There's no medical evidence.
No, you cannot. If there's no medical evidence to support an allegation, even if I believe they're telling the truth, I'm not allowed to credit it. That's basically Ninth Circuit law. Right. On the other hand, it's like the depression thing. If I think that there is some evidence of that, but it's not in writing, there's no medical evidence, I might send them out and try to have it investigated, but that's the best I could do.
I remember you and I, when I was, after being a clerk and going off and being a public defender and then coming back doing Social Security cases, I remember coming in front of you, and you were the most gracious of judges to let claimants do that, to go out for a consultative exam, to go out, to give them a chance.
Yeah, I appreciate that. Yeah.
Most. I remember a case too where, there was a question about sobriety off of DNA, drugs and alcohol, and in this particular case, it was drugs. And you said, "Hey, look, go take a drug
away, yeah,
and if it comes back clean, I will award you benefits." And so you gave people chances. Would you? Let me throw this at you.
Yep.
Would you say that medical records in a file weigh about 90% of the pie when you're taking it? It literally is that much? Or would you say it's 55, 80? I mean, just
okay. I would say probably 85 to 90%. Yeah. That's because if it's not there, it's not there. And if it's not there, like I said, I can't take somebody's word for it that they've got carpal tunnel if there's no complaints in the medical record or any evidence of it,
Not even a mention of it. Yeah.
Yeah.
I tell clients when I prep them for a hearing, like 90% of the case is based off the medical records in the file.
Right.
Doctors' opinions, consultative exams, and your treatment records.
Right.
10% is based off of everything else. So I tell them that because I think there's this overwhelming pressure on clients when they go in front of a judge that I'm going to really screw this up. To your point, the way to screw it up is just to lie or, maybe over exaggerate. But if the medical records are so slam dunk and you have doctor support and all these things, that's even if they are nervous and coming across not great, those medical records are there to support maybe why they're nervous. Like maybe there's severe anxiety, maybe there's severe depression that makes them bubble through testimony.
Yeah.
So I like to tell clients, take a little bit of pressure off yourself. We still need to prepare. We still need to go through and, you and I did a mock hearing video. You should watch that and the pre-hearing video and all the packets and information we get. The form that I think is most important when we talk about Social Security forms, I don't even know if all the judges even look at all the Social Security forms. I know most judges will look at the work history form. I know some judges will look at the adult function report form just because it's almost like testimony back in time.
Mm-hmm.
But then I'll get clients like, why didn't you call my sister to testify? Why didn't you call my husband or my brother? And I'll tell them most judges don't want to hear a repeat of what you just said.
Right.
Let's put a letter in the file. That way we get the testimony in if we want it there.
Right.
Or appeal if we lose and we have to deal with that letter from a legal standpoint.
Yeah.
Versus like, it's really like, listen, like the judge, this testimony is 0.5%, if that, of what the judge is making a decision on, right? Of that 10 to 15% in that.
Right.
You agree with that? Or, I mean, I'm kind of just...
Totally. Yeah, absolutely. Yeah. And, these hearings could go 3 hours if we allowed every witness, that wanted to testify on behalf of their brother, their sister, their neighbor, but there isn't time for that. And it's a courtesy. The hearings, the brevity of the hearing is more in recognition of courtesy to all the claimants who are waiting behind you for their hearing. You don't want to spend 3 hours. It's just not reasonable.
Let me ask you just two more questions, and
sure.
I promise you, I could just pick your brain on this all day because I love it, and I think it's really great inside information. Is there any? Because I'll watch other lawyers do YouTube videos and listen to other lawyers talk about Social Security. Is there any pressure for judges to have a certain denial percentage versus award percentage from the top, from whoever your bosses are? Is there any pressure like that?
No, never.
Never.
I never had any pressure like that. And probably the best example is that 10% judge that we were talking about a little while ago. I objected to that judge, to the regional chief judge, and I was basically told that, sorry, that's independent. That's their independence. And I appreciate that because nobody ever told me, well, you're paying too many cases or you're not paying enough cases. No, they remain pretty independent. Now, the number of hearings they do, there is pressure always to do more hearings because of the backlog, but that's different. That's not trying to influence the decision.
Yeah, no, I get that. There's a lot of publicity and I think the number one thing when it comes to Social Security disability that gets kind of in the news the most is how long it takes to get through Social Security disability. And I think a lot of people, in the spirit of what Social Security disability is and how our country runs, most people live paycheck to paycheck to paycheck. Mm-hmm. I think in their mind, they're thinking, oh, I have this life raft that's right there. Mm-hmm. And what I try to tell people, well, it's a lifeboat, but you got to swim a couple miles to get there.
Yeah.
So for a lot of folks. And if you think of it like that, then you can prepare yourself for the journey you're about to go through.
Yeah, that's good advice. Yeah.
Last question, and then we're going to have to do this again. If there was one piece of advice that you would give to a client that's, or maybe someone who's pursuing Social Security disability, what would be the piece of advice that you think would be the most valuable to put them in the best possible position to win?
Boy, that's a really interesting question. Probably be honest and don't piss the judge off. That's two things, but obviously be honest, because I've had people say, oh, my friend down the street, she's on Social Security disability. She's been on it for 10 years and she doesn't have anything wrong with her and blah, blah, blah. Well, that's somebody else. That's not you. Your case is your case, and it's different than everybody else's case. And just be straight, be honest. And the other thing is that I tell people all the time, you're going to be anxious. The anxiety of sitting there and knowing that you're being judged and having to remember all this information and share it with somebody else, you're going to be anxious. I'm really sorry. That's just part of the process. It'll be over after an hour, and maybe you'll be on benefits after that. Maybe you won't, but it's what you have to go through.
That's a great piece of advice. And then, of course, you got to have medical records. So
yes.
I always tell folks, without medical records, whether you're honest or not, and that's obviously before you even get to the hearing. You can't create medical records.
Right.
So you got to create that at the beginning,
Right.
Listen, Dan, thank you so much for your time today. I dominated a lot of it.
No, it was great. Yeah.
I'm so grateful for having you be a part of the firm, and just the years of mentorship, and and just for all the time that you've always given me. So I'm very, very grateful. So
thank you, Peter. Thank you very much. It's an honor working for you. It really is.
Well, the honor's mine, Your Honor.